Judge John Hlope is pulling out all the stops to try and halt the impeachment process against him. He has filed an urgent application in the High Court in Johannesburg to interdict Parliament's process against him and to urgently stop President Cyril Ramaphosa from suspending him. This is while he seeks to review and set aside the decision of the Judicial Service Commission, which found that he was guilty of gross misconduct last month. In August, the Judicial Service Commission found that Kloppe was guilty for attempting to sway two constitutional court justices to rule in favour of then-ANC President Jacob Zuma in 2008. All the constitutional court justices filed a complaint against him. So after a legal tussle that has lasted for years, JSC finally resolved last month to recommend that he be removed from office. But Hlophe says the tribunal process that found him guilty was unconstitutional and invalid. To discuss, we're now joined by a researcher at Judges Matter, Mbekezeli Benjamin. Mr. Benjamin, thank you for joining us. Firstly, how successful do you think the judge will be in staying the punishment, as it were, while he tries to get the findings of the JSC tribunal overturned?
Good afternoon, Francis, and good afternoon to the viewers. From what I've read in the court papers, he seems to have put up a strong argument that the process of removing him from office should be stopped while the review goes ahead. His main argument is that there are serious and weighty issues that he has taken up in the court case, and so he before those issues are decided, he wants the process to remove him from office to at least pause for now while the court case is still ongoing. And he's also explained that there is no prejudice that will be suffered by the Judicial Service Commission or the President in them stopping the process. And so that's the argument that he's put forward, but obviously the JSC might argue differently and the court will ultimately decide.
All right, but you're saying he presents a strong argument there. What about the actual weighty issues you're talking about? He wants the JSC to overturn its findings. He says it was improperly constituted when it met last month. There was no Chief Justice or Deputy Chief Justice there. Is there merit to that claim that prejudiced him?
Yes, that is a key ground that he puts forward, that the JSC was not properly constituted because some of its members, like the Chief Justice, the President of the Supreme Court of Appeal, a representative from the attorney's profession was not there. He puts all of those up as reasons why the JSC could not be properly constituted and it should not have taken the decision that it did. Now, he relies quite heavily on a case from 2013 where then Premier Helen Zille took the JSC to court for failing to include her in its processes. So in terms of the constitution, the premier of the province is required to be involved in the process, and the Supreme Court of Appeal said that it was wrong of the JSC not to include Premier Zille, and said that constitution was unlawful and any decisions that were taken were unlawful. So Judge Kloppe in this case, he uses those same arguments that then Premier Zille put up. And so that's one way that it shows that the case has some merit to it. Of course, again, the JSC might argue differently, but from what I see, it looks like that's a credible ground.
Yeah. Okay, so are you saying he could actually be successful in the courts here, and therefore this won't even go through the parliamentary process? We won't see if there will be a two-thirds majority against him, and he will remain a judge?
Look, I'm not coming to any strong conclusion. That from my assessment, that is just one ground that might possibly be strong enough for him to succeed. But of course, there are other grounds that he's also put forward, and those I think are less strong. And again, the JSC will argue differently because what we don't have now is exactly the minutes of the meetings that happened. So we don't actually know who was in the room and who wasn't. What Judge Kloppe has put forward for now is that certain key individuals were not present when the decision was taken. And because of their absence, then the decision to find him guilty of misconduct was invalid.
Yeah.
Now, the JSC will probably argue differently and say, actually, everyone who needed to be present was actually present, and so the decision was valid. Right now, we haven't seen what the JSC will say, and so it's difficult to come to any strong conclusion on that legal point.
Mbekezeli Benjamin, take us back, please, to 2008. Why was he allegedly so wrong with the conversations that he had with his colleagues? And then take us through what Hlophe has been saying, that it's natural for judges to discuss cases with each other. I don't think anybody has agreed with him on that.
Yes, so at the heart of this matter is a series of meetings that Judge Hlophe had with two constitutional court judges, that is Justice Nkabinde and Justice Jafta, that happened in March and April of 2008. In those meetings, he is alleged to have said that those two justices must decide in a particular way a case that was before him. And that case involved documents from the arms deal case that involved President Zuma. And so from those conversations, he is alleged to have improperly influenced the two justices, or attempted to influence them. And that is something that the tribunal of 2020 found that it was credible and that was misconduct. But Judge Hlophe is arguing that, in fact, this latest decision by the tribunal contradicts a previous decision from about 2011, which said that he wasn't guilty. And so he says that inconsistency between the two tribunals over the years shows that these conversations that he had are actually innocent. They are conversations that happened all the time between judges, and there wasn't any improper influence in those conversations. So that is something that he's also put forward quite strongly in this latest court case.
All right, very big implications for the judiciary. So this was meant to go to Parliament, but now there's a whole legal matter which we will follow. And thank you for your analysis, Mbekezeli Benjamin, researcher at Judges Matters.